Yes, sir. Experience.
All phones on silent, yeah, guys? Yes. All phones on silent, please.
Yes. Yes.
Yeah. Yeah.
Mic testing. Okay. Thank you. Good afternoon, everyone, and welcome to what is going to be a very informative and insightful session brought to you by the Indian Business and Professional Group of Abu Dhabi, IBPG. Legacy and Succession Will Power Panel, a very special IBPG podcast session powered by Adib Group, whose wonderful premises we are at today. Today, we have an esteemed panel who will be joining us, and they will help us to understand the importance of legacy planning and succession, especially for all of us expats that's living here in UAE. So whether you're a business owner, professional, family leader, this session will definitely shed some light on why registering a will is really important in UAE, and it's truly essential. Now, we'll be starting with a keynote session followed by the panel discussion. We do have a list of questions that we've received over the past couple of weeks by all of you and based on our expert panelists as well. We will be taking questions from the audience later on once the whole session is done, the panel discussions is done, and also from our viewers who is joining us online and the live audience. So if everyone's ready, let's start the afternoon. Yeah? So ladies and gentlemen, once again, welcome to a special session by IBPG Pod, powered by Adib Group, Legacy and Succession Will Power Panel. We start with a keynote address, and it is delivered by someone who clearly doesn't need any introduction for us in IBPG especially, the managing partner of BDO Legal UAE, Mr. PV Shaheen. Mr. Shaheen leads the UAE offices of BDO Legal, and he plays a pivotal role in the strategic direction of the firm. With nearly 35 years of post-qualification experience, he brings extensive expertise in a broad range of legal disciplines with a deep understanding of UAE laws and Islamic Sharia laws, which has earned him the trust of both regional and international clients. Please put your hands together and let's welcome Mr. PV Shaheen for the keynote delivery, please.
Thank you, Madam. Bismillahirrahmanirrahim. In the name of God, most gracious, most merciful, I welcome you all with Islamic greetings. Assalamu alaikum wa rahmatullahi wa barakatuh. Peace be upon you. May God Almighty shower His choicest blessings upon you so that all of us are prosperous. The topic of the day, I would put it as will. And we all know if there is a will, there is a way. And if there is no will, it's not no way, but it's a difficult way. So to make it easy, to make your journey comfortable, you need a GPS. And that's exactly the purpose of writing a will during your lifetime. So your loved ones don't suffer walking the hard way. So having said about the will, I don't want to go into the details. The expert co-panelists are there. They will talk about it. Now, what are the types of succession that's generally in prevalence? I would put it in three headings: testamentary succession, non-testamentary succession, and then when you have two people, always mix it, so mixed succession also. So testamentary succession is when you have a testament in place, which is the will. Once you have written a will, it's properly executed, then you have a way. That's called the testamentary succession. But not everybody is vigilant. How many people do write wills actually? See, 80% of the people, especially in Asia, you know that there is nothing which may be left behind to be called as an estate, because they are mostly hand to mouth. So only the 20%. Out of the 20%, maybe 10 or 20% may be writing wills, right? The rest are non-testamentary succession. Non-testamentary succession are by the law. And the law in India is different for different communities. We have Indian Succession Act, which is applicable to everybody, which was enacted in the year 1925, pre-independence. And rest is all personal laws for Hindus, Muslims, Christians, Parsis, Sikhs, others, okay? Now, beyond the non-testamentary succession, why am I putting a third one? People may write will, but not for the entire properties they are leaving behind. For some of the assets, they would have written a will. Rest will go as per non-testamentary succession. That's why it's called the mixed way. Now, after the succession, here, especially living in the Middle East and the Gulf countries, people mostly write wills because they are scared about something called Sharia. And why are you scared about Sharia? Because there is the general saying, we are all enemies of what we do not know. The main reason for this fear is lack of understanding. So I would say in few words what exactly is this Sharia. Sharia, the word meaning is the way. We would have heard, no? Sharia Hamdan, Sharia Khalifa. This is the street, the way, okay? And Sharia, when it is about people living in the desert, and if the way is to the water, that's the way to live, way to life. So that is how Sharia is called the way to live, which is law. Because law regulates life and problems of laws are problems of life. So now you understand what exactly is Sharia in 2 sentences. And what are the sources of Islamic Sharia? So if you want to understand the subject better, you need to know what are the sources. Where do you find Sharia? Will you find a book called Sharia? And people call Sharia law. That's a misnomer. You don't have Sharia itself means law. Why should you call law law? So Sharia you will not find in the prescribed textbook. You have to find it from its authentic sources. The first and foremost, the fundamental source of Sharia is the Quran. Quran is considered as word of God. And it was revealed to Prophet Muhammad, peace be upon him, through the angel Gabriel. In Arabic they call Jibreel. During his lifetime, from the time he became a prophet at the age of 45 until he passed away at the age of 63, over a period of 40 to 63, sorry, it's not 45. So over the period of 23 years, according to the circumstances and context, it was revealed in pieces and finally put together in the form of a book, which is the Quran we have. Quran means the one to be read. Quran has another meaning, another name, which is Furqan. Furqan means touchstone of theology. Anything related to spirituality, religion, theology, if someone presents you something, this is the touchstone. Just like we have a touchstone, when someone presents you a metal and say it is gold, what you do? There is a touchstone. You just rub on it and you will find out whether it's real or not. So that's another name of Quran. So first and fundamental source is Quran, which is word of God. I explained how it was revealed. And it remains static. Okay? It cannot be changed. It's protected until the end of the world. It is said in the Quran itself that I have revealed it, I have taken the ownership to protect it until the last day. This is the verse in the Quran itself. And the second source of Islamic Sharia is Hadith. Hadith or Sunnah is the sayings, doings and permissions of Prophet. Okay, during his lifetime when he was a Prophet, 40 to 63 age and 23 years. Okay, and during his lifetime, Prophet had stated that don't write down the hadith because it may get mixed with the Quran and that could lead to confusion. So nobody wrote it down. It was all practiced as customs, as what they heard and heard from others. Through generations, people practiced it. And when did hadith get codified as a piece of law? Is 250 years after the life of the Prophet. So you can imagine 5 generations would have passed in between. So if I tell you something now and I ask you tomorrow, what did I tell you? It will be a different story, right? So it's called the Chinese whisper. A lot of human interpolations happened. Corruptions happened. People modified it to their convenience. So it's not completely authentic as I would call the Quran. Because the time period, 250 years, AD 570 to AD 623 something, that's the lifetime of the Prophet. So after that 250 years, can you imagine? And some of the people who codified it, they collected 90,000, 100,000 hadiths and finally certified only 7,000 as authentic. The rest were either repetition or corrupted, non-authentic source. Okay, so that is the second source. When the first source is clear, there is no scope or space for the second source. Second source is only to explain or interpret the first source. Plus whatever is left out in the first source, that gap can be filled with the second source. And what if you don't find something in the hadith also? Then there is a third source which is called ijma. Ijma means collective consensus of the scholars. If the scholars of a particular time unitedly say something, this is it, and that's the law, provided it doesn't contradict with the first two. Not every place you find the scholars unanimously saying this is right. If you have 3 scholars, you'll have 4 different opinions also. So you go to the fourth source. That's called the qiyas. Qiyas is ask yourself. See, when you're going to do something, there is a discomfort coming from inside. That means this is something bad, right? So you apply your conscience, you test the situation, apply the knowledge you have gained from the first 3 sources, you will get an answer. That's called qiyas. The last 2 sources are dynamic. First 2 sources are static. That's how you make the Sharia a living law. Okay. Now, having said this much, you understood the 4 sources of Sharia, right? And once you understand the Sharia properly, there is not much to be scared about it. if it applied in the proper sense, it will not create any chaotic situations in your life. And one misunderstanding is it applies to everybody, which is wrong. It only applies to Muslims. So the Articles 17 and 19 of UAE Civil Transaction Law, I'm sure my co-panelist Advocate Devanand will be explaining it better, says that matters relating to inheritance, marriage, custody, guardianship, divorce, etc. are governed according to the personal law of the relevant person. So this law does not apply. Sharia doesn't apply to non-Muslims. Now, I said Sharia is not something to be scared of. It is adjustable according to the life situations. So why did I go to Supreme Court? For the first time in my career as a lawyer, 35 years representing others, for the first time, I have become a litigant myself. And it's not for myself, it's for the general interest of the public. It is 300 million Muslims living in India will be benefited if I get a favorable order from Supreme Court on this. It's a public interest litigation. What I'm saying is apply Quran in its authentic form. Because Quran definitely says, verse number 180, chapter number 2, Al-Baqarah, Kutiba alaykum. It has been prescribed upon you as a mandatory obligation. When death approaches you, you write a will in favor of your parents and your close family. And those who have heard the will should implement it. Okay? And changing the will or misinterpreting it is a sin. But if the testator has done some injustice to somebody, there is nothing wrong if you turn out to be a mediator in order to bring peace between the beneficiaries of the will, make small adjustments. God is all-knowing, all-knowledgeable. This is the words. So according to Quran, writing a will is not just an option, but a prescribed mandatory obligation. But when you look at the hadith, there is a particular hadith which is related to Sa'd ibn Waqas, where Prophet was visiting an aged sick man, one of his companions, and he said, I'm going to write a will giving all my properties to charity. So he said, don't leave the children in poverty, don't do that. Then he said, okay, half. Half is also too much. Okay, then 1/3. 1/3 is also a lot, but let it be. That's a contextual advice that was given by the Prophet to one of his companions. Unfortunately, during the later generations, that was interpreted as a general rule. Hereafter, Muslims should not write a will beyond 1/3 of your property, and that 1/3 will cannot be to your legal heirs, which is directly contradicting the Quran. So Quran has got the meaning, the word Furqan also, the touchstone. By applying this touchstone, that hadith cannot be applied to everybody. That's a contextual advice given. Don't give it a larger application. Even another hadith is no bequest to legal heirs. It cannot stand at all, because bequest prescribed as an obligation in the Quran is in favor of your parents and next family. So they are your legal heirs, right? So you cannot contradict the Quran with the hadith or the ijma or the qiyas. Now, there are verses in the Quran related to inheritance. Chapter 4, Surah Nisa, verses 11 and 12. That is exactly where the 1:2 ratio for daughter and son comes. 1/6 is prescribed for mother, 1/8 for wife. All this is coming. But soon after those verses, 4 times it repeatedly stated that these rules of inheritance, these prescriptions are to be followed only after satisfying the bequest. So 4 times it is stated that first bequest, testamentary succession, only what is left behind after that, the rules of inheritance, the prescribed shares are to be applied. So the order of precedence is that first testamentary succession, then non-testamentary succession. This is all over the world. The so-called Islamic scholars, with all due respect to them, probably were not lawyers, and they did not understand the difference between testamentary succession and non-testamentary succession, how they are simultaneous and coexisting, and what is the order of precedence, and that have created this chaotic situation over nearly 1,400 years. And for me, I'm trying to correct it now. I have gone up to the Supreme Court. My petition is registered as 762 of 2025. It has been admitted. It will be heard by a panel of judges, and there is an amicus curiae appointed there to give an opinion on the points that I have raised before the court. So I need support. I need your prayers to make it a big hit, a success. It's with a lot of effort. I would say decades of study, research, and effort that I have finally reached the Supreme Court. We need to make it. Now, I don't want to take much of your time. I leave it to the eminent co-panelists who will explain to you how exactly will operates in UAE, how it is executed, how it is probated, how the families stand to benefit from it. And in UAE, just one word I would add. Now the personal law and the way it is applied by the Abu Dhabi Judicial Department, they are recognizing Muslim wills as well. Provided gross injustice is not done, it is equitable, because equity and equality are not the same, right? See, suppose one is 6 feet, one other is 5 feet, you're giving a 1 foot, 1 foot stool for both of them, it is not equitable. It may be equal. So even when I am having 3 children, one may be less efficient than the others, or maybe physically challenged, I will have to give a little more. Will is required. And suppose 2 elderly couple, imagine no children, and if the only thing they have is the dwelling house, and if one passes away, the house is registered in his name. It goes to brothers, sisters, others, because there is no children. So to address all these situations, the one and only solution is the will. Okay. So this is a right given to all of us under the personal law of most all the countries. And according to Quran, it's a religious obligation to. So the Quranic prescription is matching the constitutional freedom and the fundamental right guaranteed here. This is exactly what I'm trying to implement. Thank you very much for the opportunity. Thank you, IBPG. Thank you, moderator. And I hand it over to the fellow co-panelists. Thank you.
Shaheen, we'll just move on with the panel discussions now. Hello, it's on? Okay. All right. I'd like to invite our panelists. I am going to invite our first panelist. He is the director of Kaden Boris Legal Consultancy in the UAE, heading the inheritance and personal law practice, Mr. Devanand Mahadeva. Mr. Devanand is a fourth-generation lawyer, and he's a specialist in inheritance planning for individuals and succession planning of businesses, with a vast experience of over 33 years in the inheritance laws of various countries, regions, and religions, including the Sharia. He advises his clients on matters such as inheritance tax planning, family business succession, trusts, family partition, family disputes resolution, and the likes. And also, his only gentleman in our panel today. So let's welcome him, Mr. Devanand. Please welcome him to the panel. All right, join us, please. Thank you. Our next panelist is the legal and corporate consultant at Dr. Upala Basu. Dr. Upala is a distinguished legal professional with over 7 years of diverse experience in academia, corporate legal advisory, and research. She also holds a PhD degree, especially in women's rights, and it's truly an honor to have her here with us. Please welcome Dr. Upala. Let's welcome our third panelist, the legal associate of ATB Legal Consultancy, Amy Denny. Amy is an accomplished legal professional with a broad practice covering estate planning, corporate advisory, and intellectual property law, which I'm really interested in. Amy has extensive experience in DIFC and ADJD wills registration, and she works closely with expatriate clients to address sensitive issues such as wills, guardianship, and succession planning in the UAE. Welcome, Amy Denny. And my name is Diji Shujahi. I'm the CEO and managing partner of Pinnacle Group of Companies and Urban A to Z. And I'll be your moderator for the evening. And it is truly an honor. This is something that I'm really looking forward to, because I'm someone who lives outside UAE, like most of us. And for us, this is a very informative session. So, ladies and gentlemen, please note that we have some questions already that we have received from our IBPG members and also from our panelists, based on what we've heard over the past couple of weeks and all their expertise regarding the topic. But we also would love to acknowledge the fact that we've got a live audience with us, and we request you to kindly send in your questions. We will get your questions, and all your questions will be considered and answered, hopefully by the session is over. We have time for the question and answer round. But for now, let's start with the questions. Mr. Devanand, I would like to start with you. One of the most important questions that we've received is, what is the importance of wills for Indian Muslims, non-Muslims, and will wills take priority, or will the Sharia law prevail?
Yeah, as our keynote speaker, Mr. Shaheen, has mentioned earlier, what you have to understand is, where there is a will, there is a way. What happens is that most of us, especially in South Asia or in India, we are we know the importance, or most of us are aware of the importance of having a will in place, but we are generally in a denial that, it will not happen to me, and I will not go, and I will not, which is an inevitable thing, where you will go and you have to sort out your assets. So what happens, having a will in place helps you to, decide what you want to do with your assets, your guardianship of children, and whatever you own in this abode when you leave to the next abode. But when it comes to your choice, you have to make the choice of making a will. But if you don't have a will, of course, then we split the people between Muslims and non-Muslims in this country, and then the respective laws will apply. Where for non-Muslims, it will be the civil law, and for the Muslims, it will be the Sharia.
Okay, so what do you think? Should Indian expats, both Muslims and non-Muslims, make a will and have to register it in UAE?
Definitely. Because, wills are two types. One is the private will and a public will. In India, most of the times, if you write a will with two witnesses, it's a valid document. Unless somebody disputes and you have an issue with it, it's a valid document. But in UAE, a will has to be public. It has to be registered. So you have two authorities which can register wills, and it has to be registered. Then only it's a valid document to use.
Okay. And so what is a civil will, and can a Muslim expat in UAE actually register a civil will that will cover their entire assets in UAE?
Definitely. The ADJD Abu Dhabi Judicial Department, in the last 3 years, they have come of place where to accept Muslims from any part of the world except the UAE nationals. All Muslims from any part of the world can write their will, and they can register it, which becomes watertight.
All right. Okay. Thank you so much. Just Amy, just a quick thing, just to get back on the same topic. A UAE registered will it cover foreign assets? And if yes, how enforceable are they in other jurisdictions?
Yes, so as Mr. Devanand has already explained, there are multiple jurisdictions where an expat can register a will in UAE. So one among the jurisdiction is DIFC, which is under Dubai International Financial Center, which is a common law jurisdiction. So under this jurisdiction, if an expat can register a will, then yes, the answer is yes. Like you can include your international assets as well. Like supposing an Indian expat would like to register a will in DIFC, he can include the assets in UAE along with the assets in India. And once if something happens to the testator, the person who is making the will, the executor can then initiate the probate application, get a probate order from the DIFC court, and then he can execute it in the Indian courts. Since there is a reciprocity between the UAE and Indian courts, there is a provision for execution or executing the DIFC probate order in Indian courts, which is also called an ancillary probate.
Okay. And Dr. Bala, a single will, can it be drafted and registered both in UAE and in India?
As Amy has already stated that it can be drafted, but we always suggest that there should be two separate wills for two jurisdictions, because it always depends on the jurisdictional factors and the law of the land. So it is always suggested that there should be two wills, one will for the UAE assets in UAE and a separate will for the Indian assets registered in India. Because during the execution time, it is always on the jurisdiction of the court who is executing the will. So to make it more hassle-free, we always suggest that there should be two separate wills for two different countries.
Okay, and can you run us through a procedure for will registration for Indians who reside here in UAE? Is it through the Indian embassy, like for the Indian assets?
Yes, if we want to make a will for the Indian assets, it can be done through the consular officer. So first what we need to do is we have to draft the will according to the law of India. So then after that, what we have to do is we have to take an appointment with the consular officer, and we have to carry two drafts of the will, and it needs to be attested in front of the consular officer, and there has to be 2 witnesses present. And the person who is making the will or executing the will has to carry the passport copy and the UAE residency along with him, and it needs to be signed in front of the consular officer, and one copy will remain with the consular officer and other copy will be with the person who is executing the will.
Okay. And Ms. Amy, can you give us a little bit more detail on the different jurisdictions that you did mention that is available for Indian expats to register a will in UAE?
Yes, so mostly when any expat living in UAE, holding assets in UAE, come to us, we mainly recommend or mainly suggest there are 4 different types of jurisdictions available for them. One is under DIFC codes, which is Dubai International Financial Center. So this, as I already mentioned previously, it is a common law jurisdiction. So all the language, everything will be in English. You can include your UAE assets along with your international assets, and all the probate and other applications and other processes will be carried out through the DIFC codes. So at the end of the day, if something happens to the testator, then it would be easy for the executor to carry out or initiate all the probate processes through the DIFC codes. So that is the first jurisdiction. Now the second jurisdiction is before ADJD wills under the Abu Dhabi Judicial Department. So this is the most frequent or ideal jurisdictions which an Indian expat, I would say, would like to register a will, because in DIFC it's commonly opted by expats coming from common law jurisdictions like Canada, UK, Australia, because for them it is easy for to carry out the probate process in their home country as well. So there they would be including their assets in UAE along with their international assets, so that along with the probate process in UAE, they can also carry out the probate in their home country, which is under a common law jurisdiction. Now coming back to ADJD, so this is under the Abu Dhabi Judicial Department, but the only difference is in ADJD wills you can include only assets pertaining to UAE. So if your asset is in any of the Emirates of UAE, yes, you can include it. Assets meaning it may be your financial assets, your real estate, or any other assets. Now the third, and also it is a civil law jurisdiction, meaning the probate and other things will be carried out by the mainland courts, and you will have to get the probate process executed through the mainland authorities. And also the language will be a bilingual, meaning one side English and one side Arabic for the easy purposes of the court. Now the third jurisdiction is under the Dubai Notary Wills, which is again yet another, it is initiated by the Dubai courts. A notary public will initiate the application for the registration of the will, and all the process of probate will be carried out by the Dubai courts. And the fourth one is ADGM wills, which is Abu Dhabi Global Market Will, again a common law jurisdiction, but as on date they do not have a separate law as such pertaining to the common law. So they are acting just as a facilitator to provide the wills registration services, but again it is carried out directly under the ADJD jurisdiction. So at the end of the day, even if you go with the ADGM will, the probate process and everything will be carried out only through ADJD codes.
Okay, and what does a person having a visa in different Emirates
Even
matter?
if you have different visa, it is not an issue. You can initiate the registration application before any of the authorities. But there is one difference. Supposing if you are a Muslim expat, then the only option available for you is to register a will under ADJD codes. No other jurisdictions will allow you to register a will. But for non-Muslim, they can explore any of these 4 jurisdictions.
Okay, all right. Thank you. Mr. Devanand, if a person who's made a will has passed away, what are the practical immediate steps that a family should take in order to preserve their assets?
Yeah, it all depends on where the person passes away. If they pass away in UAE, of course, they get a death certificate in English and Arabic, and they can submit that into the court and get the probate done if they have a will in place. But if they pass away abroad, not in UAE, but while traveling or while on holiday, or so when they pass away abroad, what happens? They have to get that certificate, and it has to be attested by the UAE embassy, which is after the local authorities attested, it has to be attested by the UAE embassy in that particular country, or the embassy which serves that country, because some embassies are not there. In some countries they don't have embassies, so which serves that country, and then it has to be brought in here, and it has to be submitted to the court, and it has to be implemented. Now, coming to what my fellow panelist, she was telling about different jurisdictions where you can do the wills. when you look at ADJD, it's a mainland code. So what happens when you register a will with ADJD? One is it's cost effective, and the second thing is when it comes to implementing the will, it becomes very easy because it's a mainland code. Once they give an order, everybody accepts it. And when you go into the other jurisdictions where like DIFC, what happens is that it's an offshore platform. So what happens when you get a probate document from there, it's fast. You get the probate document there, but then we have to go again to the local court to execute it. So we have to translate the whole English documents into Arabic. This I'm talking from experience of implementing wills. So we have to translate everything into Arabic, and then we have to go into a local court to implement, so it becomes a little time consuming. And when it comes to the wills which are registered in Dubai, and notarized, it's not registered, it's notarized at the notary public in Dubai, it becomes the discretion of the judge to accept the will or not. Because it's only a notarized will, it's not a registered will. So it becomes the discretion of the judge to accept the will or not. And we have had experiences where the will is not accepted and they apply the law.
Okay. And just to follow back on that, how long does it normally take to execute a will in UAE?
To execute a will in UAE, of course, it depends on the law firm which deals with it. But normally it takes about 2 to 3 weeks. Because it involves approval by the client, and then it involves translation as far as ADJD is concerned, especially when you look at Muslims, we have to translate and it has to be bilingual. So it has to be understood by the client as well as the authorities. So it takes about 2 to 3 weeks to get the appointment because it's all online. Both ADJD as well as DIFC, they are all online will registration. So we have to get the appointment to register them. So it takes its time.
Okay, thank you. Dr. Pala, are inheritance and wills completely different concepts?
No. As Mr. Shaheen has gave us a very broad introduction about what is the concept of will and what is inheritance. So I refer back to that. So will is actually the wish of the person, how he wants to distribute his assets and estates after his death. And inheritance means how it is how the assets and estates are distributed among the beneficiaries after the death of the person. So inheritance can be through a will or it can be intestate. That means the beneficiaries, they can get the assets and estates either through the will or just by being a legal heir and through the legal heir certificate that has been issued by the court, they can inherit the assets and estates.
Okay, it's clear now. And Ms. Amy, are assets specifically listed in the will or can they be left open to the executor to decide?
Okay, let's take it in this way. There are certain clients who would come to us and say that, okay, we want to specifically list down the assets, like I have 1, 2, 3, 4. Or there are certain other types of clients who come and say that currently I'm having 1, 2, 3, 4 assets, but in the future I would like to add on or acquire more assets. So what happens if I register a will now? What will happen to the future properties? So the answer is you can do it in either way. Like either if you are very prominent that your assets should be distributed equally or it should be listed down in your will specifying that your first asset will go to your wife, your second one to your first kid, your third asset to the second kid, yes, you can do that. But otherwise, what you can do is you can say a clause wherein there will be applicability of the residuary estate. Meaning, for an example, let's assume I have a cake with me. One slice is given to my wife or the husband, and one slice is given to my first kid, the second slice to my second kid. So there will be some leftovers or crumbs of cakes. What happens to that? That is termed as residuary assets, meaning the leftover things. So in the registered will, you will mention that all the residuary estate will be distributed equally between your beneficiaries. So for the end of the day, if you are having multiple assets which is not specifically being listed down in your registered will, automatically this will be given or distributed to your beneficiaries so that it will not be given outside or it will not go to any other person.
Okay, and we did discuss about the process of getting a will registered, but can you also explain more or less about the statutory cost that is associated with it, and timeline has already been mentioned, but the cost.
So basically, once depending on each testator's wishes or priorities, also considering the assets which he has, in which emirate he has got assets, and also the economic feasibility of the client, he can decide on which jurisdiction does he want to register a will. Like once a jurisdiction has been decided, he can approach a will draftsman who will help you assist in drafting your will properly in a legal way, protecting all your rights so that in future also there will not be any challenges against his registered will. Now, once the draft is in place, then you can initiate the online application through the relevant authorities. The authorities will ask you to make the statutory court fees, which you can make. And once the registry reviews and approves your application, then they will allow you to or assign you with a virtual slot for the appointment of your virtual meeting. So there is no requirement for you to be physically present before any of the jurisdictions at any point of time. All the process, everything is completed virtually. And also regarding the cost aspect, the statutory cost for DIFC wills, it starts in the range, it comes in the range group of 5,000 to 15,000 dirhams, because there are 5 types of wills in DIFC. So basically, if you want to just appoint a guardian for your minor kids in your will, you can go with a guardianship will, which is a very 5,000 dirhams cost. Now, secondly, if you only have properties, like you do not have any other real estate, then you can limit your registration to a property will. Or if you're having only a bank account, then there is a aspect of registering a financial asset will. So likewise, there are different categories of wills in DIFC, but most clients choose to go with full will, wherein it's a combination of all the assets. Like you can appoint your guardian, you can include all your assets in the full will. So for full will, for individual, it is 10,000 dirhams, the statutory cost. And for mirror will, meaning husband and wife, if both of them are having assets, and if they would like to register a will like simultaneously during the same appointment slot, then again they can go with a mirror will, which is for 15K. AED. Now, as I said, so it's considering the huge amount or huge statutory cost, most of the expats prefer to go with ADJD wills, which is 950 dirhams per will, a single will. So the cost is very different, like there is a huge difference between the cost in DIFC and ADJD.
Okay. And just to expand on this, Dr. Ibala, can you just expand on the guardianship of minor children? How does it work under a will which is registered in the UAE?
It is very suggestive and important to mention a guardian for children who are below the age of 18 years. That is the age of majority here. So anybody who is below the age of 18 years, so it is always suggestive to appoint a guardian. Through this, the person who has been appointed as the guardian will be able to take decisions on behalf of the minor child. The financial decisions, the educational decisions, or the decisions relating to a future financial planning until and unless that child, who is also a beneficiary, attains the age of majority. So once, until and unless that child, whether he or she attains the age of majority, the guardian who has been appointed, that person will be taking care of the child from all aspects, whether financially, education, or welfare. And also it is mentionable that it is not important for the guardian to be a UAE resident. That guardian can also be someone who is not a resident of UAE.
Okay, that's nice. And so what is a living will, and can it be registered and executed in the UAE?
Interesting question. Yes, living will is a very interesting concept. Is that, will is a thing which comes into effect after you pass away. But a living will is a document which you want to implement when you're alive. So how it has to be handled if you go into a coma stage, how your wealth has to be handled if you're becoming absolutely disabled. These are the reasons for having a living will. In the Western world, it's very common because people are not ready to take decisions for a person who is disabled. So it is like, I'll just give you a little anecdote here, a little story here of my own experience with my mother. See, in a European or a Western world concept, if a person is disabled and they are in a ICU or whatever it is, if you ask the children, what do we have to do? They will tell them, like, you get their permission and do things where they're disabled. But in a South Asian context or an Indian context, what happened when my mother had a heart attack and she was in the ICU and they were doing an angiogram, and the doctor comes out and says, she has a block and we need to put a stent, and if you allow me, I will do an angioplasty. Otherwise, you can take her home and then bring her later. I said, anyway, you have put all the tubes in, might as well do the angioplasty. So he said, are you the decision maker? I said, I'm her only son. I have a sister who is in London and I'll take the decision. And of course, I swipe the card. So you better take a call on that. So that is the difference, where in our society, we generally, the children or your family member will take a call, husband or wife or parents, or they will take a call saying that, okay, get along, I'll swipe the card. Okay, that is how it is. But in Western world, it doesn't happen that way. So that is the reason they have a concept of living will. We also can have living wills, but we cannot call it living will to register here. Here, the system has not got ready for the living will. But what we do around it is what we call a lasting power of attorney or an enduring power of attorney, where you put a clause in the power of attorney that only if you become disabled or if you are unable to take your decisions, this power of attorney will come into effect. So it's a power of attorney, a general power of attorney with a clause. So even if you're disabled and if you're in the hospital and you're unable to take a decision, your wife who has a power of attorney or your husband who has a power of attorney from you, a lasting power of attorney or an enduring power of attorney, can go and take a decision, withdraw your money, spend for your hospital and things like that.
Okay. And Dr. Upala, can a non-Muslim Indian expat put a temple trust as a beneficiary in the UAE, and is it allowed as it is allowed in India?
Yes, a non-Muslim, it is very much allowed in India. We are very much aware that we can put a temple trust or a charitable trust as a beneficiary in a will in India. So any Indian and non-Muslim who is making a will in the UAE can always put a temple trust as a beneficiary, provided all the details of the temple trust are specifically mentioned in the will. As we already know that a temple trust is a legal body or a legal person. It is under, in legal jurisprudence, it is considered as a legal person or a legal entity. So that is why a temple trust can always be put as a beneficiary in a will.
Okay, all right. We have some questions we've received from the audience. Also, we have some questions that's been actually written into us earlier. There's some which has already been answered, but I'll just still ask some of them, which I feel can be elaborated a lot more. If someone passes away in UAE and has outstanding liabilities, such as credit card loans, property loans, other debts, will these pass on to the beneficiaries of the will?
Interesting question. Yeah. If you leave a liability, whether it will pass on to this thing. If you want to inherit, it's a balance sheet. So if you want to inherit the assets of a person, then you have to pay the liability. Like you, for example, you have a car which is worth about 200,000 dirhams, and there is a 100,000 dirhams loan, hypothecation loan. 100,000 is already paid. And you want to inherit that car which is valued currently at 150,000, you have to pay the 100,000 to get the 50,000. So that is how it's a balance sheet. But the liability is more than the assets. The liability doesn't pass to the inheritors or the beneficiaries. So because always as per law, liability dies with the person. So they cannot come and claim from the family what the person owes. But you want to inherit, yes, you have to pay the liabilities.
Okay. And this is also following up on that. If a deceased person's bank account or telephone connection is not closed, would the arrears or unpaid amounts need to be settled by the successors? So
it dies with a person. Okay. If they don't want to inherit, they don't inherit.
All
That's
right.
it.
Okay. And if the deceased hold any shares and stocks in a company, can a will facilitate the transfer of those shares at the relevant government authorities to the beneficiaries?
Yes, so as I already mentioned or stated, asset can include your financial bank accounts, your real estate properties, even company shareholdings, bonds, debentures, insurance, vehicles, or antique artworks, or anything like even crypto assets are also considered or treated as an asset. So yes, you can include it as an asset in your registered will, and it can be carried on or it can be transferred to the beneficiaries.
And should the will specifically list also like the details of the bank account numbers, property names, locker details, everything?
So the thing is, like if you do not want to, if there is no issue or no harm in not listing out or specifying the list of assets in the registered will, because at the later point of time during the probate application, the court will ask the executor to surrender a detailed list of assets of the testator as on date of the death of the testator in order to evaluate and issue the probate order. So at that time, the executor should be in a position to release or issue this detailed list of assets which the testator has. So even if at the current moment you are not including the list of assets in detail in your registered will, it should not be an issue for you in the future.
Okay. And Dr. Pala, what would be the process, general process to transfer the title of a property in UAE to wife or children if the property is mortgage free? And also, how does it differ if it is under the loan? Because both, you know.
If there is if there is a will, so automatically the title will be transferred to the beneficiary who is there. But if there is a mortgage, so as Mr. Devanand has already specified that if the liability is there, so it will die with the person who is the testator. But if there is a mortgage, and as he has given the example of the vehicle, so it will be in the same way. If he wants to acquire the property, so he have to give the rest of the amount and then acquire that.
Okay, understood.
But if you look at it practically, what happens is that most of the mortgages are covered by insurance. So what happens when a person passes away with a mortgage of a property and with an insurance, the insurance pays the mortgage. So the property becomes absolute. So once you get the order from the court, after submitting, after the probate is done, when you get the order from the court, that order can be given to the land department in respective emirate, and they will transfer the asset to the beneficiary. And always remember, we generally pay a larger amount for buying and selling assets in a percentage, but it's a very small amount which is paid for the inheritance. So it's not considered as a sale of property, but it's an inheritance of property.
Okay, all right. We have some questions from the live audience. We're also ready to take questions from the floor. If anyone has, yeah, we have a question here. Yes, please. We'll get you a mic.
Thank you so much for such an informative discussion on succession planning. So my question is to do a little bit on the conflict of laws. So hypothetically, let's say there's an Indian British national, and the UK, for example, has inheritance tax, for example. And we register a will in the UAE, everything's sorted. How would you manage the conflict of law in the UK as opposed to, let's say, the UAE?
Very good question. Like you have a British national, for example, as you say, or an Indian who has assets in the UK. Okay. And of course, UK has an inheritance tax. So that is what we say, just not writing will, but you have to plan your inheritance. So we don't call it as writing wills. As a practice, as lawyers, we always say inheritance planning. So when you do inheritance planning, you have to just not write a will or a living will or a lasting power of attorney, whatever it is. You have to plan your inheritance, and especially if you have nationalities where there is inheritance tax, you have to plan your inheritance tax liability as well. So what happens now, for example, in UK, what matters here is that whether you're ordinarily domiciled in the United Kingdom or you're not ordinarily domiciled. So if you're not ordinarily domiciled in the UK, say, for example, permanently you live in UAE as a resident, you are not liable to inheritance tax in the UK, except for fixed assets which you have in UK. So anything above the value of £350,000, you had to pay 40% as inheritance tax to His Majesty's Inland Revenue. Only after that you can inherit. But we have inheritance planning for that as well, where we have whole of life insurance, which will cover the inheritance tax liability with the beneficiaries as beneficiary. But then you have something called tenancy in common and joint tenancy in the UK, where between husband and wife you will inherit without any inheritance tax liability. Okay, so that is what is important. But again, there are a lot of Indians who own properties in Western world. So remember, if you have fixed assets in the Western world, a lot of our clients, Indian clients who come and ask, I have property in London, I have property in France and things like that, they are liable for inheritance tax for the fixed assets as per that rates, even though they are not domiciled there or they are not citizens of that country. So that has to be taken care of in your inheritance planning. That is where you have to have the right advice.
Thank you. I'll just like to take one question from our live audience. Mr. Prakash Mehta has, this has been answered. I would like for you to expand on it. What are the steps for will's probate in case it needs to be executed?
Okay, I did explain to it. So first thing is, like, if you have a registered will in ADJD or DIFC, the only thing which is required is the death certificate and the passport copies of the latest passport copies of the deceased, as well as the executor, as well as the beneficiaries. So these are the documents which we require to probate a will and to get a registration, because you don't have to prove anything else. You don't have to prove the will because you already registered the will. Okay, but if it comes to a will notarized at the Dubai Notary Public, then we need a larger process where we have to prove various things.
Okay, and Amy, wills that are registered in ADJD, will it include assets across all UAE and Dubai?
Yes. So in ADJD, there is no limitation for you. Like if you hold any assets anywhere in the UAE, yes, you can include it in your ADJD wills.
Okay. Questions from the, yes. You state your name also, please.
My name is Binoy. There aren't any legal complications in this. This is a question for the common people's perspective. So if I heard right, the DIFC will is costing around 10,000 dirhams, whereas the ADJD will is costing 950 dirhams. So, as somebody from the layman, is there anything specifically that I should know? Is there any specific advantage I gain if I do a DIFC will? It's almost 10 times, 950 dirhams and 10,000 dirhams. So, what additional benefit do I get, if at all I get anything, so that I can make an informed choice or decision?
So if you are registering a DIFC will, it matters when you probate the registered will. So during the time of probating, if you have already a registered DIFC will, it will be very easy for your executor to get it probated, meaning the executor can just simply send out an email to the DIFC wills registry in English language, attaching a copy of the registered will along with a death certificate. So the DIFC wills registry from their end will be assigning a case progression officer who will be initiating or helping the executor in initiating the probate application, which makes it very much easy for the executor who is sitting in some other country, if he is not locally available in UAE, to initiate the probate application and do the probate process. And once the probate order is received from the DIFC courts, now there is a recent development wherein you can take this DIFC probate order executed directly, like meaning you can take it to the relevant DLD or any authorities in Dubai mainland, and you can get it probated, meaning the properties can be transferred. So there is no requirement or involvement of the Dubai courts in executing this DIFC issued probate order, which makes it very easy for the people holding assets in Dubai or in any, if they are holding assets in any other Emirates, yes, again they will have to approach the mainland courts for doing the execution process. Now coming to ADJ, ADJD, since this is under the civil law jurisdiction, during the time of probate, there is a requirement for you to engage a Arabic counsel to initiate the application and carry out all the translation and other documentations in Arabic and to initiate the process. So, which is, as a expat who is not very much aware of the Arabic language, it would be difficult for you to find out a local counsel and then initiate the process, everything in Arabic. So, that's the main difference.
I would differ from what she does. I currently have 22 cases in the court where I'm doing probate. When you do a will, it's a very nice question of the costings. But, what you have to understand is DIFC is a free zone authority, and where ADJD is the mainland court. So that is the reason for the difference in cost. Because in ADJD is more of a service, where in DIFC it's more of a free zone authority situation. Now, coming to the execution of it, executing an ADJD will is far, far easier because it's a mainland court. It's far easier than the DIFC because DIFC as an experience of executing those wills, DIFC wills, what happens is that because it's a free zone authority, many of the, even the banks don't accept the probate of DIFC. Document, which we have to go again to the local court of the respective emirate where the visa of that person is from, and then we have to get an execution order from that particular court, and then we have to go into that particular land department or the business DED or to the RTA of that particular emirate. Where when it comes to ADJD, because it's a mainland court, it gets accepted by the banks and the rest of the authorities straightforward. And both of them accept probates online. Both of them, you can get your probates online. And interestingly, ADJD gives judgments, even in other cases, they give judgments in 6 different languages. You can get judgment out of ADJD in English, Arabic, Mandarin, Russian, Hindi, and Urdu. Okay, they're far ahead of that with things. And what happens is that you get this probate order and then you can implement it in different departments. Of course, it involves a process, and the executors, if they cannot come here and do things, they can always appoint a local lawyer. And it does, in ADJD, it doesn't have to be Arabic speaking because it's a bilingual court. ADJD is a bilingual court as of time, and in personal status court, where they do the probates and the family dispute cases, they now allow foreigners as well to practice.
Thank you for clearing that. But a general question that's been popping up is, which one is better, DIFC or ADJD?
Oh, that is a very tricky question because as lawyers, we are on both sides. Okay, we get licensed by both the authorities. We have a draftsman license there and we have a license here. We cannot give you what is better. Get your individual advice. Get your individual advice, what is required for in your particular situation, and then take it from there.
Okay. Just one quick question from online, because a will that has been registered over 5 years back in Abu Dhabi, does it have to be updated?
No, it doesn't have to be. Once you make a will, it's a valid will for ever till you make a new will. Okay, it's always called a last will and testament. Okay, so once you make a testament, you don't have to change it. You change it only when your circumstances change. We always look at, we tell the clients to look at, say, after 10 or 15 years, have a look at it, because your children may settle down in different countries where there are inheritance taxes. They may change nationalities. They may have children. You want to keep aside something for your grandchildren and things like that. So you second.
Just to adding on, sir. So in DIFC, there is a provision for amending the registered will.
Yeah.
So even in case if you have already registered a DIFC will and later a point of time you want to change your beneficiary, you want to include some other asset, yes, you can do so. But whereas in ADJD, there is no provision for amending a will. But instead of that, you will have to register a fresh will again. So that's one difference.
Yeah, the cost.
Yes, correct.
Okay, I hope that answered your question, NJ. Also, this was asked if a Abu Dhabi property is in will, is registered in Dubai courts, which was in 2015. Is it still valid? I think it's just a Abu Dhabi property in will, non-Muslim, registered in Dubai courts, 2015. Is it still valid?
It's a valid document. There is nothing wrong with it, but it is ideal to register your document because what you have done in Dubai is a notarization process. If you can spend that extra money and register it at ADJD, it's ideal.
And is it the same for a will which is registered in Dubai courts to be valid on DIFC? Same. No? Same. So just taking all the questions. This was by Sharmila. All the live questions that's coming in from our live audience, we would encourage you to keep sending them. We've got a few more minutes, so it'll be nice. Yes.
Further to the question, Sudhir Balakrishnan, further to the question like DIFC and ADJD, is there a restriction locally wise Abu Dhabi resident cannot do it at DIFC or anything vice versa?
No, it is nothing like that. Any resident of UAE can register a will either through Abu Dhabi Judicial Department or through the DIFC. So there is no restriction that anybody who is a resident of Abu Dhabi have to do it through the ADJD, or anybody who is a resident of Sharjah have to do it through Dubai courts. It's nothing like that.
Just to
Adding to that, 50% of our clients don't have an Emirates ID in UAE. They write wills in UAE, they don't have an Emirates ID, or they are not residents here, because there are a lot of foreigners who own properties here, who own businesses here, but they don't have a resident visa here, and they can write wills. Nothing wrong in it, and they don't have to come here even, because both these jurisdictions, ADJD as well as DIFC, do wills online, so you don't need to come to UAE as such.
I just had a question. I think you just answered. You don't need to be a resident to register a will here, right? And if a resident registered a will in India, for example, can that be executed for transfer of assets in the UAE to the beneficiaries residing anywhere in the world?
Good question again. I think I'm taking the execution part of it here because I'm hands-on in that practice. See, what happens is that you can have a will made in India. As I told you, in India you can have a private will or a public will. Private will is if you sign and two witnesses sign, it's a valid will, which will not be accepted here. Okay. The other thing is you can register a will there, or you can notarize a will there. The issue here is that you cannot bring that will and implement it here because they want it registered here. Okay. So what you have to do is you have to probate that will. You have to submit to a court over there, and then the court has to give an order validating that will. It's called the probate process, and then they give you the heirship certificate. You have to attest everything and bring it here and submit to the court here. And that will be accepted by the judge at his discretion. So whether the judge can accept or not, that is left to the judge, or we may have to go for an appeal of it. Now, I'll tell you the practical difference in this. Where if you have an ADJD registered will, it takes about a month or two to implement it. So your accounts gets unfrozen, your business can be transferred, your property can be transferred, your car can be transferred to your beneficiary. For example, if you have a will to probate in Bombay, it takes 1 year. Okay, so you have to wait 1 year to probate that will in Bombay, and then you have to do all the attestation, bring it here. You're looking at about 1.5 to 2 years. So do you want to hold the assets and all the car and everything for the next 1 year or 1.5 years? It doesn't make any sense. That is what it is.
This question is from from Jayanti. Why does the Indian law not allow power of attorneys to be granted by the spouse who is disabled and uncommunicative caused by health concerns, and unless he is able to give consent? Why does Indian law not allow power of attorney to be granted by the spouse who is disabled and uncommunicative caused by stroke unless he is able to give consent?
Because if they are not in their right mind, if they are having a stroke or this thing, they cannot give a consent. So they cannot write a power of
So in
attorney.
that case, a power of attorney should have been
Done beforehand. So that is what we were talking about, the living will or the lasting power of attorney or enduring power of attorney.
Okay. For a young person under 30 who may not own major assets but wants to be prepared, what are the key things to know about legal will and what common mistakes should they avoid?
I think we already discussed like what are the positive benefits of having a registered will. Even if you do not have any real estate property, even if you do not have any kids, but later on you can at any time add on any real estate property. You may have future kids as well. So it is always better that you being an expat having or living in UAE, it's always better to register a will in the UAE itself so that it will be easy for your beneficiaries, for your loved ones to carry on or take away your assets once something happens to you.
My youngest client is 23 years old.
Now actually it's not for the old people to register, it's all the young generations who are registering.
DIFC and ADJD again. Can a will be created in both ADJD and DIFC?
There is no requirement for it. I mean, either one is fine. I mean, why do you want to complicate your life and...
No, just adding on. So in DIFC will, you need to give a declaration that you do not have a registered will in any of the other jurisdictions. So of course, if you are planning to do a DIFC registered will, then you can only do it in DIFC. So it's always better that you do it in any one jurisdiction.
This is Srinivas here. Hello.
And if a will is registered in Dubai courts, will it be valid in DIFC?
Yes.
No. See, if a will is not registered in Dubai court, it's only notarized. So a notarized will in Dubai court cannot work in DIFC as such because you don't need to. Because DIFC, you don't own anything there. It's only a registry authority. So when you have a will notarized in the Dubai court, what you have to do is you have to implement the will. You have to go into Dubai court and get a probate done from the court as such.
Questions from the audience?
Is it the same thing? Once I have done the will register in DFC,
Louder,
is it
please.
valid in...
Louder, please. We can't hear you.
Hello. This is Srinivas here. Once I have done the will in DFC court, the will is been done. And is it valid in India or is there any restrictions within the India to execute?
See, in UAE, DIFC is the only jurisdiction wherein you can include your international assets. So yes, again, if you are holding assets in India, you can include it in your DIFC will. But again, getting it probated through the Indian courts, like you will get the DIFC probate order issued by the DIFC courts, which you will have to take it to India and get it executed, which is called an ancillary probate or revisiting of the wills. So again, the process will have to be done in the local courts in India, which is again time consuming. So it is up to the testator to decide. It's always better, as lawyers, we would usually suggest that it's better to have wills in different jurisdictions. Like in UAE, include your UAE assets, and in India, include your Indian assets, because it's easy for you to probate and to carry out or issue or distribute it to your beneficiaries.
Yes, and to add on, it actually depends mostly on the law of the land. Like maybe somebody have registered a will in UAE and wants to have it executed in some state of India. So we very much know that the courts of India, it has various laws, like each state has different land laws, each state have different laws relating to the execution of a will. So it gets very difficult during the execution time. So the main purpose of a will, that the beneficiaries do not have to face any hassle and it becomes hassle free. So if the beneficiaries during obtaining the probate, if they have to go through so much hassle, then it is no point of having a will. So that is why we always suggest that each jurisdiction should have a separate will so that it becomes hassle-free for the beneficiaries, which is the entire purpose of the base of having a will.
Another question, and I think this is one of the last few questions. If there's any more questions, please feel free to send it on our live feed. How important is having a legal team in all this? And will someone be able to do this by themselves online, or do they need a lawyer?
You want us to shoot ourselves in our foot, huh? Yeah. See, it's very straightforward. You can do it yourself. Okay. Now, you have a fever. I'm not talking about COVID times. You have a fever. 1 or 2 days you have fever, you will have a Panadol and get going. But if you have a fever for 3-4 days, what will you do? You will go to a doctor to get an opinion whether what sort of fever this is. Okay. So that is what happens in this will process or inheritance process as such. You can self-medicate, you can do your own draft, you can submit to the system and write it on your own. Nothing stops you. Nothing stops you doing that. You want to get a draft, you can get it online, you can do it yourself. But the difference is when you go to a lawyer, each person's profile is different. And when you go to a lawyer, they'll be able to advise you based on your particular requirement, what has to be advised and what has to be done. So it's like how a doctor deals with different bodies, we have to deal with different profile of clients. So that is the reason it's good to have a legal help to do it. And when you look at the costings, like if you're going to register a mirror will in ADJD with the legal fees and translation fees and everything, it costs, if you're buying a decent car, it's going to be about 75 to 100,000 dirhams. And it costs a fraction of it, not even a down payment of a car's value to make your will when you are investing millions of dirhams in your business and your properties and things like that. So not to consider costs, but it's better to have proper advice before you do your inheritance planning.
Okay. Indian nationals in UAE having investments in USA. Where should they make their will? India, USA, UAE? And also, to piggyback on that, if beneficiaries are US citizens, is there inheritance tax?
Very good question. I was waiting for it. I was waiting for that question. See, you cannot be doing wills in every jurisdiction you own things. We all have offshore investments. Most of us, because of tax reasons, we all have Isle of Man, we have Virgin Islands, British Virgin Islands, we have Guernsey, Jersey, whatever it is. So what happens is that how these jurisdictions work is, what we would ideally advise, as we are talking to IBPG here, what I would ideally advise to Indians or people of Indian origin who have assets elsewhere. What you have to do is have a separate will for UAE, registered, and have another will done for India, which you can sign it at the embassy here or the consulate here in the outsource center. So have a separate will for your own country of nationality. So if you don't own an Indian national, you're an Indian origin but have another nationality, have for that nationality. Now what happens here is that these sort of offshore platforms or countries where you don't own a nationality, you can take the probate of one of these countries, either from UAE or from India. You can take the probate, the court order, and implement it there. Okay, either the country of your nationality or country of your residence. And we have seen this happening in the course of things. So if you have a US asset, you can implement your Indian will or the UAE will. The UAE will is faster. Implementing is a couple of months, where the Indian will can take more than a year. So the fastest one, you can use it in the US. Now coming for the beneficiaries of the children are US national and
it's
inheritance tax. See, inheritance tax is for the estate of the deceased. So as far as you're not a US citizen, it's not an issue. Okay, your children can inherit. They can be US citizens and they can inherit. But once they inherit, they have to declare, and their inheritors will pay a massive tax. So as far as you're not a American citizen, don't worry.
All right. Any more questions? I think we can wrap it up. Any more questions live or from the audience here? Just trying to quickly go through. Question? Okay. Yeah. I would like to just couple of minutes, couple of words from all of you. Just what did you think about the session, and we can wrap it up. Yeah, you start. Okay.
So, as we all discuss now, as an expat whom we have assets, we may be having real estate asset, financial property, bank accounts, or any assets in UAE. It's always recommended and suggested that we go and have a registered will in place, because for the future of the beneficiaries, it will be hassle free in order to distribute the property to them. We do not know what happens to us in the future, so anything can happen. So it's always better that we make a document proof, and get it registered, so that there will not be any issue for the future generations to pass on our hard-earned assets which we have. So thank you, IBPG, for conducting such a podcast. I hope this would be beneficial for all the expats, especially the Indian expats holding assets in UAE. And thank you, my co-panelists, as well as my moderator also. So thank you so much.
Thank you, Ms. Amy. Can we have Dr. Upala say a few words, please?
First of all, I would like to thank IBPG for organizing such a event where not only the persons who are on the other side of the podium learning, but even I am also gaining more and more knowledge with such experienced persons who have been in UAE for so long. And also, I think we do not need to tell any more to the people who are already attending this podcast that how important it is to make a will, because as Mr. Shaheen has already told, where there is a will, there is a way. That means it shows a way to the beneficiaries that not only during the lifetime you are securing the assets, but even after the passing away of the person, the beneficiaries will be safe and do not have to face any hassle later on in their life. So I am very thankful to IBPG once more for giving me this opportunity to be as a panelist in this such enriching session about the will. Thank you.
Thank you so much, sir.
Yeah, it has been a wonderful experience joining all the ladies here. and doing a live podcast as such. And, thank you, IBPG, for having me around. They have given me a membership also on an exceptional criteria. And so what is very important is having your inheritance, not just the will, your inheritance organized. See, when we call as inheritance, it's not only, if many of you are business people, have your business succession also planned. It's not just writing a will in place, just it's going to so and so. But most important is, if you own a business, your business succession is very important. Otherwise, you are leaving behind a complication where you're not going to have any goodwill to encash, or what you have worked hard will go waste. So along with your inheritance planning, always see that you plan your business succession, who is going to take over your business. You may have multiple children some will be interested in your business, some may not be. So have your proper business succession along with the inheritance planning, not just writing a will. So get the proper advice and organize your inheritance. That is very, very important. As far as not only in this country, even back home. Many people come here and say, Vakil Saab, I need to have a will made here because they are talking about Sharia and all those things. I need to have a will here. I ask them, do you have your things organized back home in India? They say, Udhar kuch chalega yaar. I don't need anything. I don't need anything to be organized there. But it's very important. If you look at the crux of the Indian courts of the cases in the Indian civil courts, or sometimes in the criminal courts as well, about 50 to 60% of the cases are indirectly inheritance issues. Somebody has not written a will, or some senior person in the family has not done a partition. It's all family fights. It's not commercial fights as such. So that is what is very important. Our court system in India is choco-blocked because of these issues. So it's always good to organize your inheritance for the good of yourself and your family. Thank you.
Thank you. Thank you so much. This has been a very insightful session. And again, we'd like to thank IBPG. It's a very special episode of IBPG podcast, powered by Adeeb. We are joined here by the CEO of Adeeb Group, Dr. Ansari. Just want to welcome you to the stage, please. Thank you so much. Just a few words.
Good evening, everyone. It was very informative because I know, I understand, I know Shine was connected with me, but the very informative, very interesting, insightful information which is shared, it's really useful for that. Thank you for everyone.
Thank you, thank you. And special thanks again to Adeeb Group. We are using their beautiful space here, and they've been supporting IBPG and especially our podcast for a long time. So we are really grateful. Thanks to the entire team, managing committee of IBPG for organizing this, and to the REDX team. Thank you. Hope you all had a good afternoon.